People v. Baldner.
May it please the court. Good afternoon, Your Honors. John Ingrassia, along with Michael Bongiorno for Appellant Christopher Baldner. Chief Judge Wilson, I would like to reserve 3 minutes for rebuttal.
Yes.
Thank you. We appear today before this court to respectfully ask this court to reverse the Appellate Division 3rd Department's decision and order which reinstated the depraved indifference murder and depraved indifference reckless endangerment charges against our client. I think in order to understand this case, I would respectfully suggest we really have to look back at the setting and the factual backgrounds of both the 2020 goods incident and the 2019 Muthu incident. That's very important because, as we know, this court held in Feingold in 2007 that the depraved indifference case law, the depraved indifference statute requires the actual subjective mental state, showing that heightened recklessness, grave risk of death, along with both depravity and indifference to human life. Starting first with the goods incident, 2020, I think there are a few things that are undisputed. We know that there was a lawful stop by the state trooper, Christopher Baldner.
Counsel, before we go through line by line of the proof, can you frame your argument in terms of the posture of this case? So Feingold, I believe, was a conviction after trial.
Correct.
Right? What you're asking us to do is stop this at a grand jury stage. So there's no development of this proof that you're talking about now. There's no jury that's considering it and considering inferences. What you're asking us to do is, based on a grand jury presentation, to stop the prosecution. And the case that comes to mind, of course, is the more recent one of Edwards, where we talked about that standard.
Yes.
And we said it was met. So in the context of Feingold, but more importantly in the context of Edwards and a grand jury, why isn't it the same result as Edwards?
Certainly. So I think in order to answer that question, I think we first have to understand, obviously, the court, trial court, appellate division, or now obviously this venue, the Court of Appeals, does have the statutory ability to inspect and reduce and dismiss if the evidence is legally insufficient, conceitedly, viewing the evidence in the light most favorable to the prosecution and drawing reasonable inferences afforded to the grand jury's finding. I think, Judge, in this case, to get to the question of the Edwards decision, we have an entirely different set of facts and circumstances. And again, this goes to the heart of that subjective analysis
Does the
of the predicate.
procedural posture make any difference? How does it matter that we are at the grand jury stage as opposed to, as in Feingold, as Judge Garcia said, looking at this after trial on a conviction? Or maybe your view is it doesn't matter at all?
My view, it matters to the extent of what the actual standard of proof is.
Okay,
Obviously,
and how does that bear? Can
sure.
you?
Well, the standard of proof still must be established. Certainly at trial, proof beyond a reasonable doubt. But in the grand jury, there is still an applicable standard of proof that's required to be carried by the prosecution.
And what is it here?
Reasonable cause to believe, right? Which is certainly less of a standard than proof beyond a reasonable doubt. But the core elements that this court has defined, particularly in motor vehicle contact cases, still must be met under that lesser standard of reasonable cause to believe.
So if I'm understanding you, your view is if we take the grand jury sufficiency standard, which is we're going to view the evidence in the light most favorable to the prosecution, we assume that they can establish all of the facts that they argue support their case, draw all the reasonable inferences that one would from that, that as a matter of law that would never constitute depraved indifference. I see that that's the only path you have to success here. But correct me if I'm wrong.
Judge, I apologize. I'm a little bit hard of hearing.
I'm
I do
sorry.
have hearing aids.
I'm saying I understood that your argument could only succeed if you can persuade us that under the standard that applies in the grand jury context, which is we're going to view all of the evidence in the light most favorable to the prosecution, draw all reasonable inferences in their favor, that if we did that, even then, as a matter of law, that would not constitute depraved indifference. I take that is your position.
That is correct, because you still have to The grand jury still has to have sufficient evidence upon review of the appropriate court meeting those necessary core elements. And when we, again, compare the proof in this case, both related to the 2020 goods incident and the 2019 Muthu incident, it falls short of that for several different reasons.
How is hitting, in the 2020 incident, hitting that vehicle a second time at over 100 miles an hour when the pieces of that vehicle are all over the road? How is that not depraved indifference, as a matter of law?
As a matter, I think we look back, again, at the context of the setting. Number one, we have a police officer who was drawn into a high-speed pursuit. Number two, we have a police officer who is authorized and legally privileged and who has a duty to enforce the vehicle and traffic law as well as the penal laws of the state of New York. And three, I think if we look at that.
Do you take into consideration that it was a vehicle and traffic law violation as opposed to, for instance, an armed robbery?
I think that is a relevant factor that goes into, for lack of a better word, the equation of determining. It's a factor to be considered. But what we do have, okay, is we do have conduct that was not initiated by the appellant, Trooper Baldner, in either of the two incidents.
Well, an officer makes a decision based on their training and the requirements of that training, the protocols that are established, as to how to respond to things as they unfold, correct?
No question about it. And I think in the grand jury, Your Honor, Sergeant Morano testified for the prosecution about, he was Trooper Baldner's supervisor, about what the protocol is. Trooper Baldner radioed, he was in pursuit, the motorist took his pepper spray, called out his mile marker, they put out a red flash, which is essentially radio silence, and Sergeant Morano indicated that this chase, the pursuit, was very, very quick. And in fact,
But there could be another view of this evidence that the pepper spray wasn't taken and that the person decided to speed away because the trooper was pepper spraying him and his family, and as he took off, the pepper spray fell into his car. I mean, that's an equally plausible interpretation.
that could be, and I would respectfully suggest, though, that that's still not dispositive of what the proper analysis should be, is what Trooper Baldner's mental state was. What Mr. Goods did, or the reasons why he did, is not dispositive as to the determination of this again, wickedness, evil, brutal, heinous state of mind.
So there's testimony, I believe, from which you could conclude that the officer hit the vehicle twice, right? And so why wouldn't that be sufficient as a matter of law to allow a jury to consider whether there's depraved indifference?
We respectfully submit, Your Honor, that it's not consistent with the case law established by this court in motor vehicle contact cases. And
Well, the case law, I thought, looked, for example, at whether there was evasive maneuvers, attempts to avoid a collision. And it seems to me that there's a read of the evidence that did not take place, and that instead there was an intentional hitting of the car 2 times. So wherever a jury might come down in evaluating that, why is it not sufficient to proceed as a matter of law?
Well, I think I would answer that a couple different ways, Your Honor. Number one, when you spoke of the evidence of non-evasive intentional maneuvers, and this is laid out both in our brief and our reply brief, we believe there was impermissible and improper testimony injected into the grand jury.
Can I ask you specifically about that? Can you explain, I take it this is your reference to the specific comments by Mr. Ruth and also the specific comment by Mr. Good, is that right?
Correct.
Okay, so where did you, how is that properly before us? Your adversary suggests it's not.
How is the issue of the admissibility
Yeah.
of, or the inadmissibility, rather? Again, in our reply brief, we address that. If we begin with the premise that this issue certainly was raised in the court below. Right? In addition, this court is still charged with the responsibility, as any reviewing court on grand jury legal sufficiency, with determining whether there is reasonable cause to believe that the elements are met based upon competent and admissible evidence.
But I think that the argument that was made was that the question of admissibility was not raised with respect to sufficiency, but only with respect to whether there was a defect in the grand jury proceeding, and so that's why it's not properly before us.
Judge, I believe, and again, I could be wrong, but I believe in our motion practice, we did raise that, and certainly during the oral arguments, and there were two oral arguments, one in front of the trial judge, one in front of, one in May of 2022, the other one, I believe, in November of
Is
22.
there a place in the record that you could point us to see where that was raised in the context of sufficiency?
If I can have a moment, in our reply brief, I think, Judge, we did indicate that on page 10 of our reply brief, we reflect, we also raise the argument in support of the motion dismissed for legal insufficiency, contending the motion the motion court should not consider incompetent testimony when determining whether there was sufficient evidence to support the depraved and indifferent counts. Record on appeal 23 through 36, 41, and record on appeal 205.
Thank you.
At oral argument, county court questioned the prosecutor extensively on that issue and appeared skeptical that the evidence was properly admitted. Record 237 to 244 and record 248.
Thank you, counsel.
I see that my time's up. Thank you.
May it please the court, Matthew Keller for the people.
Applying the standard, viewing the evidence in the light most favorable to the people, what evidence supports the result here in your favor?
Your Honor, I would first point the court to the conduct itself, as some of the court's questions have already made clear. The deliberate collisions, and this is in relation to the December 2020 incident, the deliberate collisions, 10 seconds apart, at speeds at least of 100 miles an hour with respect to the second collision, 130 miles an hour with respect to the first collision. There was testimony by the expert and by the two New York State police supervisors that this not only was the defendant required to ask permission before attempting this, he wouldn't have gotten permission in this instance
What do
because
you
of the
say
quick speeds
about
involved.
defense counsel's claim he was a police officer charged with enforcing the law, and he was simply performing his duty?
We're not disputing that at all. He was certainly on duty when he did this. But as Your Honor's question to my adversary suggested, police officers are required under every circumstance to follow their training, follow the practices and procedures. And the evidence before the grand jury here was very clear what he was required to do in this situation. The supervisor the night of the 2020 incident.
Do you need the expert's testimony, specifically those sections related to the defendant's state of mind, in order to have a legally sufficient indictment here?
Not at all, Your Honor, and we would just rely on the Third Department's decision, which didn't address that question at all. In their lengthy exposition of the evidence, which I think shows that there was significantly more evidence than was required to support a charge here. And again, remember, we're not talking about a finding of guilt after trial. We're talking about a grand jury finding reasonable cause to charge. All you have to look at is what the third department did here, and they described all the other evidence that supports the finding. And I would just point that.
But the court has been very clear that depraved indifference really applies to, in the rarest of cases, it's a very, very small set of prosecutions that could bear this particular charge. What makes this that kind of a case? As a matter of law, as I said before to your friend on the other side, assuming you can establish everything, we're going to view it as favorably to you as the law requires, drawing all inferences to you. What gets you there as a matter of law, even with this standard that applies at the grand jury?
I think there's a short answer to your question and a slightly longer answer, and the longer answer goes back into the initial question of what the evidence was. So I'll give you the short answer first.
Mm-hmm.
The deliberate contact, the expert testified and the accident reconstruction witness also testified that the evidence showed that the defendant steered the front of his vehicle into the rear of the goods vehicle twice within 10 seconds. Your Honor's I think the best description of your views and of your question on this was your opinion in the Maldonado case, where you said what you really need to show is evidence of that the defendant just simply did not care what the results of whether grievous harm resulted. And I think that deliberate collision at these high speeds, the second of which when the car was in front of him was fishtailing, attempting to regain control, and more specifically, the slight differences in trajectory between the two. In the first one, he mostly hit it front to back. That's why the expert testified it wasn't a pit maneuver.
But why isn't that just recklessness? Like, how do you get to depravity? And do you only get to depravity through inference? Or do you have evidence of his subjective intent?
Well, I think like most homicide cases, you rarely have direct evidence of the defendant's state of mind. And as this court has made clear in several opinions, circumstantial evidence is just as good to get you there. And here, the circumstantial evidence is the evidence of, from the accident reconstructions expert, the accident reconstructionists, and the expert saying that to deliberately ram a car from behind at speeds, as high as 130 miles an hour, it's just such a high likelihood, and this is directly coming from the expert's testimony, it creates such a high likelihood that death or serious bodily injury is going to result, that you would not do it unless you simply did not care what happened. There's been no allegation here. Our theory is not that this is not a case like the cases that precipitated Feingold, where prosecutors were too often.
You're saying it's evil and heinous?
It is evil and heinous, Your Honor.
So are you not relying at all on the alleged lack of concern for the victims post-crash?
We are relying on that, and that's part of my longer answer, which I was just about to get to, Chief.
Can you
Before
address- Sorry. Can you address when you do that, specifically how what you call the lying to his supervisors bears on the question? I'm not sure I've seen something like that in our case law as relevant to depraved indifference.
Yeah, as a general matter, Your Honor, it's relevant to his consciousness of guilt, and I think that's sort of uncontested and uncontroversial. But where it specifically relates to the depraved indifference finding is that the lying in real time, from the moment it happens and then continuing afterwards, shows that he's lying about what his state of mind really was. Because had he thought that this was, that this was acceptable or authorized under the circumstances as his papers suggest, he would have said that, especially after the grievous harm resulted. There would be some sort of explanation,
But he
some
may
sort
be
of
lying
attempt to justify.
because he thinks he was reckless, made a mistake. Not that he's acting with depraved indifference, that he's acting in a way that's evil and heinous.
I think the fact that he's doing it in real time as it's happening, within that 10 seconds in between, and again, I just want to go back for a second. My adversary has argued that this was sort of a split-second decision by a police officer just trying to do his job. It was not. There was no, the only urgency created by this situation was by the defendant. As the supervisors testified, the training was to when you have someone who flees a stop or who won't stop for you, you pursue from a safe distance, and you talk about it with your supervisor. You talk about what your options are. You talk about the road conditions. You talk about the criminal conduct. That, is it only a vehicle and traffic law? Is it only speeding, or is it something more serious? You talk about who else is in the car. He didn't do any of that.
Counsel, can you use the first incident as a prior bad act to prove the second? Is that your intent here?
Well, I think the trial court found, during that lengthy oral argument on the motions that you likely could, but that's not how we charged the case. We charged it as a separate standalone act.
I have a different question going back to my initial question on the standard, and I'm having some trouble, frankly, understanding how our standard layers on top of the grand jury and a sufficiency analysis. So the standard in the grand jury to return an indictment is what?
You have to find a prima facie case of all the elements of the charges.
Meaning,
and reasonable cause to charge.
Reasonable cause, substantially lower than beyond a reasonable doubt, right?
Substantially lower than even, I think, preponderance.
If you do that, you get a true bill and the indictment is valid.
Yes, Your Honor.
So now we're taking this analysis of sufficiency, and under our precedent, we're saying to dismiss an indictment on the basis of insufficient evidence before a grand jury, a reviewing court must consider whether the evidence viewed in the light most favorable to the people, if unexplained and uncontradicted, would warrant conviction by a petty jury. I'm having some trouble understanding how that maps over the grand jury standard, because it seems to be holding the prosecution to a higher standard than reasonable cause.
I agree with you, Your Honor, that that wording is a little bit confusing, but I would just point
Let
to...
me put it to another way. Do you think getting a grand jury true bill could be valid, but yet be insufficient under this test?
Insufficiency in the grand jury is different from legal insufficiency when you're reviewing a jury's verdict after trial, because you're reviewing it with an eye towards proof beyond the...
My
Yes,
question
I'm
is,
sorry.
could you have a valid true bill, which you established reasonable cause on the elements, prima facie case, yet when somebody makes a motion like this, it could be determined that it was insufficient?
No, Your Honor, because you're still reviewing the grand jury from the standard that it was required to meet.
So why wouldn't the standard be sufficient evidence to show reasonable cause to believe the defendant committed each of the elements?
Reasonable cause for a grand jury to find
Right.
that under any view of the evidence in our favor...
Why isn't that the standard in a grand jury?
I think it is. I'm sorry, I may be
It
misunderstanding
seems to
your
be
question, Judge.
articulated differently, and I was on the court that decided Edwards, but it seems to be articulated differently as if unexplained and uncontradicted would warrant conviction by a grand jury.
Would warrant conviction by a jury at trial.
A jury, I'm sorry, a petty jury. So is there a disconnect there?
I think the standard could be phrased maybe a little bit better, but I don't think that there's any question that it's not the same standard as reviewing a jury verdict after there's been a trial when the court has a full record. And I would just point to this court's decision in Jennings, which we cite in our brief, which says manifestly this court's decisions reviewing jury verdicts after trial are not binding when we're in this context, this grand jury pretrial context. And so I think Your Honor's question is suggesting, are the two standards ultimately the same? And my answer is they're not. The standard, the people have a considerably lesser burden here to warrant a trial.
Can you address Scott versus Harris? So there the Supreme Court said that an officer's attempt to terminate a high-speed car chase, and I think it was using a pit maneuver, didn't violate the Fourth Amendment and found summary judgment on a Section 1983 action. So the underlying, view, I think, animating Scott is that an officer in that circumstance is attempting to protect the public, and it's a quickly unfolding situation, and the court is going to, provide some leeway there. So how does that bear on what we have here, if at all?
I don't think it bears, Your Honor, because it's a separate legal question.
It is a separate legal question, but how does the underlying insight, what do we make of it?
Initially, I would like to point out that in Scott versus Harris, the fleeing plaintiff in that case, because it was a civil case, the chase had gone on for a lot longer. He already intentionally crashed into the police officer's car. It was a much more populated area, and most importantly, the police officer asked for and received permission to hit the car.
Right, so is that what makes it different? Because, there the Supreme Court said that the civil action couldn't even proceed, right? And here we're talking about a serious criminal charge. So is that what makes the difference? Is there something else?
It's that, Your Honor, and it's more. This is, the issue before the Supreme Court in Scott was qualified immunity.
Yes.
And what a reasonable officer could find, with his understanding, with a reasonable officer's understanding of the Fourth Amendment, what he could reasonably have thought. In criminal cases, it doesn't work like that. It's subjectively, what was in this defendant's
I
mind.
would be surprised, I guess, setting aside the doctrinal points, that if conduct that was reasonable for purposes of the Fourth Amendment and a Section 1983 action was also criminalized and as a serious offense at that. Now, maybe the answer is that the conduct, in fact, is different given the facts, but I just thought it would be helpful to get your view.
Conduct is certainly different given the facts. It's also, qualified immunity is a policy judgment at the end of the day. It's a policy judgment that we don't want to be, we don't want the courts to be interfering too much into the actions of law enforcement. Our legislature has made no such finding. They could, I suppose. They could pass a statute that qualified immunity extends to criminal liability, but they haven't. And again, the facts are very different. Here, there is no reasonable view of the evidence that what the defendant did here was authorized or was legitimate or was warranted. And at minimum, which is all we have to prove at this point, there was a reasonable view that it wasn't authorized.
Getting back to the distinction between recklessness and depravity, I noticed during your presentation you didn't rely in any way on the fact that there were 2 hits in the 2020 incident. So I take that to mean that you would have legally sufficient evidence of depravity for a grand jury just based on the first hit in 2020. Is that right?
I think at this stage, I think a grand jury could find reasonable cause to indict had there only been 1 hit. But here we have to, and because I thought I had relied on the 2 hits, and so let me go through.
I was waiting for you to draw a distinction, but I don't think you did. I mean, you might have mentioned that there were 2, but.
No, and I sort of got caught up in when I was going through the list of all the evidence. So let me just go through it again. The 2 hits, the eyewitness testimony that after they left the stop, within a minute, they didn't even know the officer was behind them, suggesting that he didn't even turn on his siren, that within a minute of them fleeing the stop, the first hit from 130 miles an hour, he hits them from behind. That's the first indication they had that he was behind them. All 3 surviving.
I guess my question is, could that be reckless? Along the lines of what the dissent was saying below, leaving out the fact that he went back and did it again, could that hit at a high speed without the lights just be reckless behavior?
Certainly the manslaughter charge, the grand jury voting a manslaughter charge indicates that they did find it reckless, and they found it also met the greater standard of depraved indifference, not only based on the 2 hits, which I've already discussed, but also the EDR, the event data recorder evidence that he turned into the car, no attempt to avoid. I think the expert said it was the opposite of an avoidance maneuver.
Wasn't there something about hitting the brakes in 1 or both of those hits?
That's what the trial judge relied on primarily for his reducing and dismissing the depraved indifference charges, was that, he looked at another recently decided third department case and said, well, if that guy in that case braked to avoid, then this defendant, I can't see how we can charge him. But
Isn't there a danger that prosecutors might expand depraved to every situation where a fleeing felon is driving a car, driving at 110, 120 miles an hour? That's not unusual. Hits other cars, people are injured. That's not unusual, right? I mean, that happens all the time, especially in rural areas where a lot of these crimes are on highways. I mean, isn't there a danger if we find depravity here based on that suddenly everything in those situations is depraved versus just reckless? And aren't we supposed to retain depravity for the very wicked cases that we've already outlined?
I don't think that's a reasonable risk, Your Honor, for three reasons. First, these facts are highly unusual. You don't see facts like this every day. And as this court has said in Heidgen and other cases, the depraved indifference finding is highly fact-specific. So it's rare that one case is going to map onto a wide variety of other cases. Number two, a lot of those cases where there might be an incentive or a feeling to charge depraved indifference where a lesser charge is warranted, the vast majority of those cases are intoxicated driving cases. And this court has made that concern clear in its prior decisions. And as the court has said, as Your Honor said in Maldonado and Chief Judge Wilson, as you said in your dissent in the Edwards case, the legislature has crafted an extremely graduated series of criminal statutes so that the prosecutors can pick from a menu. Here you do not have an intoxication case. And again, I suppose, the legislature, if it wants to, can do like what it did in the intoxicated driving cases and sort of adopt lesser standards. But it hasn't done that. And the only inference that can be drawn from that is that it wants prosecutors, where the facts warrant it, in the rare cases, and again, this is an extraordinary case, to charge depraved indifference and charge manslaughter and let the jury hear all the facts on a full record and sort it out.
Thank you.
Thank you.
Thank you. There's this comment about intentionality. Prosecution can't get to depraved indifference without intentionality. That's the critical distinction between Mr. Ruth's testimony and the impropriety of it. And as Judge Garcia, I think you, Mr. Bongiorno, hey, on our drive up here this afternoon, we're talking about this. The law does say, if uncontradicted, right, or unexplained, so I take that to mean that the court, the reviewing court on legal sufficiency, does have the ability to certainly scan the record. I would respectfully invite the court.
I take it the other way. I think
Okay.
the court doesn't have the ability to scan the record. I think it's assuming there isn't anything in the record that contradicts it. I think that's how I take it.
But there is something in the record here. And
No,
would-
but I think we don't look at that. That's for a jury.
Well, I would respectfully submit, however, that when you get to that level of whether the evidence is legally sufficient, all evidence in the grand jury should be reviewed.
Well, that's really not even how it works with a verdict, right? Because we assume the prosecution got every reasonable inference from that evidence. I think it's even lesser standard, it seems, from our cases with respect to the grand jury, which is they only need to show reasonable cause in the grand jury. And our standard to me seems to say their proof on each of those elements, assume it's uncontradicted, do they make it? And it's even then a little bit odd to me because when you're doing a Feingold analysis, what's your end product is a verdict. So you're analyzing, all right, giving the people reasonable inferences, could the jury get to beyond a reasonable doubt? And it almost seems like our standards are layering on some type of verdict standard when really the end game here is an indictment. So it seems to me it's proof that establishes reasonable cause, if uncontradicted, for each of the elements.
So going back, though, you still have to reach that level of depravity and indifference. In our position,
Establish reasonable cause, right?
under a reasonable cause standard, absolutely. And I would respectfully invite the court to look at Grand Jury Exhibits 46 and 47, which lay out the data from the event data recorder, which Mr. Ruth testified to. And again, this wasn't just a breaking. This was a very hard, almost emergency-like breaking, in the words of the prosecution's expert witness. That, in the very short time period between the first collision and the second collision, approximately 9.5, 10 seconds, goes to the level of the subjective nature, or lack of
That's a
depravity.
great argument to make to the jury. a different inference can be drawn. That's where we're left when we're deciding this as a question of law regarding the sufficiency to the grand jury.
I'm sorry, Judge?
I'm saying that's a very good argument to make to the jury at trial, but all we're deciding here as a matter of law is whether or not this was sufficient for
I
the grand
understand, but as a
jury.
matter of law, I understand, as a matter of law, I would still respectfully suggest that it still has to be met. The other thing I think that's very
Sorry,
important
it still has
remember-
to be what? What, I missed your, over here, I'm
Oh,
sorry.
I'm sorry.
I missed your last, as a matter of law, it still has to be what?
Make out the necessary elements as depraved indifference has been defined by this court.
Of course, but it seems, you seem to be suggesting in various ways that we need to look at the totality of what the evidence was before the grand jury and cull something out of more innocent explanations, which, by the way, I think is exactly what we carved out in Edwards. We said that there might be other innocent explanations is entirely irrelevant to the sufficiency analysis.
And I'm not suggesting that that's the standard. What I'm suggesting is, looking at all of the evidence, it still has to amount to depraved indifference. The other thing I think that's important to look at, Your Honors, is that this was a very dynamic situation, right? Both vehicles were moving.
Why isn't what he described, because he was asked at the very beginning by at least two of us, what establishes depravity? And at least with the 2020 incident, he described this second hit and the timing of it and what was already the condition of the vehicle after the first hit. Why isn't that enough?
Why isn't that depraved indifference?
Correct.
That second hit?
As a matter of law.
Well, I would submit that the second hit is not because of the braking. That's the most common thing. And
And if there's a different inference that could be drawn regarding that brake, the brake, right, that he's stepping on the brake, does that mean you lose?
I think the braking and the steering are both relevant. Now, my adversary, colleague,
He's
indicated.
presented a different way of
Right,
thinking
right.
about that. And if the grand jurors, excuse me, could have drawn that inference and viewed the evidence that way, strikes me that what you're doing is debating the propriety of the inferences, and
Well,
we can't do
looking,
that
though,
here.
at the other evidence,
Okay.
and again, going back to, I might sound like a broken record here, but going back to the significance of Mr. Ruth's testimony about the intentionality, because I just don't think they get to depraved indifference without that.
Well, let me ask you this about that, and we'll leave out, what's his name, Ruth?
Mr. Ruth, yes.
Yeah, leave out his testimony. And just looking at the acts, and there was a question, I think it was from Judge Singas before, about people in other situations driving at high rates of speed and engaging in all kinds of obviously reckless conduct. But one theme that I seem to glean from those cases is that they're trying to avoid, hitting people while they're fleeing from a situation. This involves, to me, clearly sufficient evidence before the grand jury that this was an intentional contact between the cars twice. And the intentionality of it, to me, seems to speak to his state of mind regarding his concern for the consequences of his actions.
So intentional conduct at those speeds, one could infer an intent to cause serious injury or death. An indictment
I'm saying
seeking-
one might also be able to infer a lack of regard for the consequences of one's actions.
And I think we're getting now into the area that Judge Rosenblatt spoke about, I believe it was in the Sanchez case, about prosecutors, the danger of prosecuting intentional acts for depraved indifference when they can't necessarily get to the intentionality. And we're obviously having a discussion here, what was his motivation to intend to cause death, intend to cause serious injury for having the pepper spray taken? And remember, both vehicles were moving towards each other. The line of cases that this court has held depravity in motor vehicle contact cases deal with a sustained course of reckless driving, usually consisting over miles, intoxication.
This
or-
wasn't sustained because the hits, destroyed the car. I mean, it couldn't have continued at that point.
Right, because the trooper was trying to get the vehicle to stop.
No, I just mean you referenced the duration, and it seemed to me that,
Right, but it's a relevant fact, right? The other thing is, again, going back to the subjective mental state, doing a job, and I think Justice Egan commented on this in his dissent from the appellate division, doing a job, but doing it with poor judgment, that's the antithesis of depraved indifference. Perhaps it's reckless. He's indicted for manslaughter second degree,
And would
which
you
survives.
categorize those two contacts with the goods vehicle as just doing a job, I'm
Well-
sorry, without due care? Or?
Well, in the context of his pursuit, in the context of the very short distance, in the context of both vehicles moving towards each other, in the context of the trooper having radioed ahead to his sergeant or to dispatch, not gotten any instruction back to terminate the pursuit, which again is a relevant factor.
Do you-
And no authorization to engage in a pit maneuver, right?
There's no authorization to make any type of contact.
And was there a request for one?
There was no request for any type of vehicle contact.
And did he give information with respect to what was occurring that arguably there's contradictory evidence as to the accuracy of that? And does that matter?
In the context of that he was rammed by the other
In the-
vehicle? Yeah.
And as to his state of mind, taking into consideration the facts and circumstances as they existed?
There's no question the trooper 2 times indicated that he was rammed. Again, I think we addressed this in our main brief, in footnote 12, about the context, a dynamic situation, a lot is going on, a high-speed pursuit. He's trying to apprehend a fleeing, an unlawfully fleeing motorist at that point in time.
In a traffic case?
Thank you.
Thank you.